No, you're not here on a traffic citation. You're here on contempt. I'm going to,
Are we having a contempt hearing, Your Honor?
well, I'm going to give you that opportunity. I'm going to advise you if you'd like it. Let me start by reading the relevant portions of the contempt rule, Mr. Forenza. This is Rule 407. This is of the rules of civil procedure, but that same rule applies to criminal actions such as this one. I'll read the relevant sections. Subsection A1, disorderly or disruptive behavior, a breach of the peace, boisterous conduct, or violent disturbance toward the court, or conduct that unreasonably interrupts the due course of judicial proceedings, behavior that obstructs the administration of justice, disobedience or resistance by any person to or interference with any lawful writ, process, or order of the court, or any other act or omission designated as contempt by the statutes of these rules. This will be direct contempt, and I will cover that in a second, but the rule is contempt that direct contempt is contempt that the court has seen or heard and is so extreme that no warning is necessary, or that has been repeated despite the court's warning to desist. Subsection 4 defines punitive sanctions for contempt, which includes punishment by an unconditional fine, fixed sentence of imprisonment, or both, for a conduct that is found to be offensive to the authority and dignity of the court. Most notably is subsection B, as in boy, which says addresses direct contempt proceedings. When a direct contempt is committed, it may be punished summarily. In such case, an order shall be made on the record in writing reciting the facts constituting that contempt, including a description of the person's conduct, a finding that the conduct was so extreme as that no warning was necessary, or the person's conduct was repeated after the court's warning to desist, and a finding that the conduct is offensive to the authority and dignity of the court. Prior to the imposition of sanctions, the person shall have the right to make a statement in mitigation. Mr. Forenza, I'm going to offer you that opportunity in a little bit. I make a specific finding that all conduct that I'm referencing occurred in my presence and therefore is direct contempt. Very specifically, let me make some reference. Mr. Forenza has been disrespectful to the court, to opposing counsel, and even to my clerks throughout the proceeding. He has filed spurious documents. He's made nonsensical arguments. He's been argumentative with the court, but I was willing to let all of that go so we could try the matter. On the day of trial, which I believe was November 24th, Mr. Forenza appeared on time, but stayed in the gallery along with who I believe is his wife. I repeatedly, at least 3 times, but perhaps 4 or 5, told him to approach the court, to cross the bar and sit at table so we could address the trial. Mr. Forenza failed to do so in my direct presence. He told me I had no jurisdiction, left the courtroom, and then amazingly.
Before we even step foot into this courtroom, let me set the stage, because this case is a perfect example of how sovereign citizen logic completely collapses the moment reality shows up. What started as a basic traffic case spiraled into something much bigger, not because of the charges, but because of the defendant's ego. This guy didn't just challenge the system, he tried to ghost it. He demanded a jury trial, showed up, and then decided he didn't feel like participating anymore. So he walked out. No arguments. No defense. Just pure defiance. Now here's the twist most people don't understand. Courts don't stop functioning just because you don't believe in them. Judges don't lose authority because someone says the magic words, no jurisdiction. And when you disrespect the process, especially in front of a full jury, you don't get applause. You get consequences. Today's hearing isn't about traffic laws anymore. It's about contempt. It's about accountability. And it's about a judge who is about to methodically, calmly, and legally dismantle every illusion this defendant thought he had. Buckle up.
November 24th, other than a few pleadings that I'm guessing were filed that day or the day before. I've had no interaction with this case since November 24th. I make a finding that Mr. Forenza was under an order to perform, that is to come to the table. He refused to perform in accordance with that order, and even though he had the ability to perform, obviously he was mobile, he was able to make it into the courtroom and then, of course, make it out. He was repeatedly warned, and I note that. I gave him multiple opportunities to approach, and he disregarded all of them. I make a specific finding that I find Mr. Forenza's conduct to be offensive to the authority and dignity of the court. I make a specific finding that he engaged in misbehavior that rises to the level of obstruction of justice. The behavior happened in my presence. The conduct was intentional and willful, and these actions seriously affronted and disrupted the administration of justice. In that regard, I will note that I went and met with the 30 or so jurors who had appeared for the trial that Mr. Forenza simply blew off. I had to explain why that happened, and I had to waste all of their time. I also wasted the time of the witnesses. Mr. Forenza, I didn't waste anybody. Mr. Forenza also wasted the time not only of the jurors, but of the witnesses, counsel, the court, and everyone else. The court finds him in direct contempt. I made a similar record on the morning of trial, but Mr. Forenza had bolted from the courtroom, and therefore I find he was not advised at that time, so at least not in any significant way, and I hereby advise him. I am considering a jail term for the contempt unrelated to the underlying charges, Mr. Forenza. I'm going to offer you some opportunities of how you want to proceed. First, if you wish, you can make the statement of mitigation right now, if you wish to. If you do not wish to, if you wish to consult with counsel, I will give you time to hire your own counsel, but you will remain in custody during the interim. I would even be open to the appointment of counsel if you believe you are indigent. In fact, I would appoint counsel if you were indigent. How would you like to proceed? And if you'd like a few moments to think about that, I'm fine with that.
Is that the only option is how I like to proceed, or can I make a statement?
Right, so I'm offering you option one and options 2 and 2A. Option 2A and 2B. Option 1 is you can make your statement of mitigation right now, right? And without counsel, the only person in the room other than court staff and the deputy is Mr. McCall. We are live streaming. You can make
This right here is a classic sovereign citizen framing tactic. Notice what he's doing. He's deliberately minimizing the situation. He wants you to believe he's being treated unfairly over a traffic ticket. But that's not why he's in chains. He's restrained because he disrespected the authority of the court, ignored direct orders, fled mid-trial, and stayed on the run for months. Courts don't restrain people for ideology. They restrain people for behavior. And the judge immediately corrects the record, because facts matter here. This isn't punishment for speech, it's consequences for actions. When you walk out on a jury trial, you're not making a statement. You're committing contempt in the judge's presence. And once that happens, the courtroom...
If you are indigent, the actual language is in a Supreme Court guidance which says, Colorado, I'll just read it to you, Colorado Rules of Civil Procedure 107 and 407 provide for the appointment of counsel to an indigent person cited for contempt where a jail sentence is contemplated. I am